Good morning and welcome to the webinar on the implementation of the transparency regulation in the context of Part C of Directive 2001/18. The aim of this EFSA webinar is to help applicants and other stakeholders to better understand how EFSA implemented the requirements of the transparency regulations, its processes and tools in relation to Part C of the GMO Directive. My name is Simone Gabbi. I'm the team leader of the Transparency and Confidentiality team in EFSA's Legal Affairs Services unit, and I will be moderating today's webinar. For today's event, we have 114 registered participants representing food industry, laboratories, research organizations, national competent authorities from Europe and worldwide. As some of you are already aware, the Directive 2001/18 prescribes that any person, before undertaking a deliberate release into the environment of a GMO, submits a notification to the national competent authority. That notification should contain a technical dossier of information, including a full environmental risk assessment, appropriate safety and emergency response, and a proposed use of labeling and packaging. EFSA is then involved in the assessment workflow at the request of the Commission when objections are raised by the Commission or by a notified member state. Today's presenters are Gunda Kritz and Pietro Pifanelli, joined by several contributors in the Q&A session, and notably Francesca Volpi, team leader in the Legal Affairs Services unit, Claudia Parisi from FDP, the front desk workforce planning unit, Alexios Zonpas from EFSA's iData unit, as well as the colleagues from DG Sante of the European Commission, Alexandra Uckelman, as well as Alexandru Dan Anastasiou, Dominic Turnbull, and Estera Cretu. My colleagues will be helping us with the handling and management of the questions that you will be submitting throughout the webinar in the chat function that we will see in a minute. What is the goal of the webinar? The aim is to explain the implementation of the GMO Part C procedure following the entry into application of the transparency regulation on the 27th of March 2021. We will provide a brief overview of the pillars of the transparency regulation and the new tools made available by EFSA and the European Commission. We'll also outline the key steps in the risk assessment workflow and process, as well as the confidentiality assessment process by EFSA, and finally conclude by addressing questions from the participants in a Q&A session immediately after the closure of the presentations. Out of scope in the present webinar are the clarifications about aspects of the authorization process which have not been affected by the transparency regulation, renewal applications, confidentiality assessments by notified member states. We have seen that we have two presenters, Pietro Pifanelli, Scientific Officer in the NIF unit of EFSA, and Gunda Kritz, member of the Transparency and Confidentiality team of EFSA's Legal and Affairs Services unit. Pietro will be discussing about the risk assessment, adoption and publication of EFSA's outputs, while Gunda will be focusing on the confidentiality assessment process of requests submitted with regard to GM food and feed notifications, and in particular under Article 39C of the General Food Law, Regulation 178 of 2002. You can submit your questions via the Q&A feature on the top of the navigation menu of your interface that we will see in a minute, and the contributors will address them in the live session. EFSA organized several webinars in the past few months about how it implemented the transparency regulations in sectors of so-called regulated products. Among those, we must highlight the following ones on this slide that could be of interest of you given the proximity to the subject matter of the present webinar. So you will find here a webinar on the application procedure for GMOs, except the GM Directive, a webinar on the implementation of the transparency regulation requirements, tools and services of a more general nature, as well as a webinar of last year regarding confidentiality assessment and content sanitization. To be noted also that EFSA organized and scheduled a webinar on confidentiality that will occur on the 27th of this month. Now, a few words to briefly explain how the interface that you're seeing and using currently works. You're automatically connected on listen-only mode, and in the presentation window, you will see the presentation and the speaker giving the presentation. On the right-hand side, you have the Q&A box that you can use to submit any question related to the topic of this webinar throughout the event. This webinar is being recorded, is in English, and questions should be submitted in English through the platform. Questions, as we said, will be answered live by our speakers in the Q&A session. If some questions remain unanswered, you can resubmit them via the Ask a Question Connect EFSA tool. Finally, the presentation in question will be made available on our website in a few days after the webinar. Now, a few words about the transparency regulation that, as we said, became applicable as of the 27th of March 2021. The transparency regulation is said to be based on four main pillars. One regarding transparency, which achieved a better access, both of the public and of EFSA, to scientific studies submitted by applicants to support their application dossiers, as well as in information and generally data supporting the dossiers, but also information that is used by EFSA to support its scientific outputs. The second pillar ensures the availability of more reliable and independent studies, as EFSA has more access to relevant scientific evidence regarding requests for authorizations. This includes also the ability of outsourcing independent studies regarding points highlighted as uncertain by the risk manager. The third pillar is represented by a better governance, which includes a more inclusive approach for member states who participate and take an active role on the core governance of EFSA, including its management board. The last pillar concerns an effective risk communication, ensuring a better link and better communication to stakeholders and the general public. The transparency regulation has been implemented by a number of IT tools and platforms that have been put in place in cooperation by EFSA and the European Commission, in order to implement the different requirements set out in the transparency regulation. EFSA put in place the Connect EFSA platform, which empowered the notification of studies database, put in place and then allowed the pre-submission advice workflow, which allows applicants to seek the advice of the European Food Safety Authority before the submission of notification or application. The Ask EFSA tool, the public access to documents workflow, which refers to the possibility for citizens and third parties to submit requests to documents held by EFSA, as well as a consultation platform for member states as well as the general public. The Commission put in place the e-submission food chain platform, which allows the automated e-submission by applicants of their application dossiers or notifications, including requests for information and replies to additional data requests. Last but not least, EFSA is operating the Open EFSA platform, which allows third parties and citizens to monitor the risk assessment workflow and empowers EFSA to comply with proactive disclosure requirements of non-confidential information. Having concluded this brief overview of the tools in place, it is now the time for me to give the floor to our first presenter, Pietro Bifanelli. Pietro, the floor is yours. Thanks.
Thanks, Simone. Good morning, all. So I will proceed with the presentation. So as Simone anticipated, my presentation will focus on the risk assessment, public consultation, adoption, and publication to be carried out by EFSA. First of all, I just wanted to, let me see, to illustrate, sorry, there is a little mistake here in the order. Let me see. I do apologize. So the first part of my presentation focuses on the workflow of the GMO Part C dossier intake. So which are the steps from business operator submission, so the notifier, to the national competent authority, down to the involvement of EFSA. So as Simone mentioned, the tool to be used by the notifier is the e-submission food chain platform. So the business operator submits to the national competent authority the GMO Part C notification, which should consist of a technical dossier and the confidentiality requests of specific sections of the dossier notified then by the business operator. At this stage, Commission is also informed of the notification. As a first step, the national competent authority will carry out completeness and notification study checks of the submitted GMO Part C dossier, and if needed, will submit a request for information to the business operator. The national competent authority will also carry out a confidentiality assessment of the confidentiality requests submitted by the business operator, and might ask missing information following the request for information. So then the business operator will be requested to submit the missing information, and the national competent authority might also request clarifications to the submitted set of confidentiality requests. Then the national competent authority will carry out a risk assessment of the notified GMO Part C dossier. And at the end of the risk assessment, there are two different potential scenarios. So no objections are raised by the national competent authority, and the national competent authority will proceed with the authorization workflow. In this case, EFSA is not called up by the national competent authority. So the second scenario is that the national competent authority will raise objections or will issue a decision not to place the GM plant on the market. In this case, Commission will send specific mandate to EFSA asking to assess the technical dossier under Directive 2001/18 EC Part C. 90 calendar days will be allocated to complete the risk assessment by EFSA. So at this point, as I mentioned, the technical dossier is made available to EFSA, and the received dossier is to be considered as valid by EFSA. As I mentioned earlier, the completeness check and the notification of studies checks were already carried out by the national competent authority. At this stage, EFSA will be asked to make publicly available via the Open EFSA platform the non-confidential version of the GMO Part C technical dossier received from the national competent authority. The GMO panel experts then will execute the risk assessment of the GMO Part C dossier. So a public consultation of the non-confidential GMO Part C technical dossier will then be launched upon receipt of the dossier from the Commission. Sorry, upon receipt of the mandate from the Commission. And as I mentioned, this non-confidential version of the dossier is uploaded in the Connect EFSA platform. The public consultation is launched. Duration of the public consultation will be of 3 calendar weeks. Upon receipt of the public comments, those will be published in the Open EFSA platform, which, as Simone mentioned, is the dissemination portal of EFSA. And these public comments will be then assessed by the GMO panel experts, and the outcome of this assessment will be published in Open EFSA as an annex to the scientific opinion. So the aim of this public consultation is to collect new or additional evidence, data, or information to support the experts in assessing the GMO Part C dossier. So let's see in detail the risk assessment by the GMO panel experts. As I mentioned, the valid dossier is received, and as a first step, the EFSA scientific officers and external contractors supporting EFSA activities in specific areas will carry out the pre-risk assessment, which means, for example, the GLP scientific compliance of the submitted studies. The GMO panel experts then will proceed with the risk assessment of the different sections of the technical dossier and will discuss the outcome of their risk assessment in the 3 standing working groups: the molecular characterization, the comparative and environmental risk assessment, and the food in feed working groups, and in the framework of the ad hoc cross-cutting working group. Should the GMO panel experts identify gaps in the submitted studies, data, or information, those will be discussed at the in the light of working group meetings. And should the expert request to receive additional data by the business operator, then EFSA will deliver this request to the business operator. The business operator then will deliver to EFSA the requested additional information, and any confidentiality request submitted by the business operator at this stage will be assessed by the national competent authority. The GMO panel experts will then assess the additional information in working group meetings, and as I mentioned, will proceed to the adoption of the scientific opinion and to the publication of the scientific opinion. So just to summarize, the main points relating to the risk assessment by EFSA are the risk assessment of the technical dossier upon a mandate from Commission, the publication in Open EFSA, the public version of the GMO Part C dossier, the launch of a public consultation, the risk assessment of the technical dossier, and at this point, should any effect, foreseeable effect on human health, animal health, or the environment, which concerns items that were granted confidential status by the national competent authority, the Article 39 review process of the concerned confidentiality requests is launched. So then I hand over to my colleague Gunda to then present the following section of the webinar. Please, Gunda.
Thank you very much, Pietro. Good morning, ladies and gentlemen. My name is Gunda Krish, and I work in the Transparency and Confidentiality team of EFSA's Legal Affairs Services Unit, led by Simone De Gabi. Today, it is my pleasure to present you with an overview of the confidentiality assessment process of the GMO Part C notification, especially as far as EFSA's involvement is concerned. Pietro has already mentioned in his presentation that it is primarily the national competent authority that has been tasked with the confidentiality assessment in relation to GMO Part C notifications, and that it is both in relation to confidentiality requests submitted with the initial dossier, but also in relation to confidentiality requests submitted in response to an additional data request. EFSA will only be involved if two preconditions are satisfied. First of all, the European Commission needs to send a mandate to EFSA asking it to carry out the risk assessment. And as Pietro has explained, this happens when an objection is raised and maintained by a member state, or if the assessment report indicates that the GMO food or feed should not be placed on the market. The second precondition is that the GMO panel identifies in the scientific opinion that there is a foreseeable effect on human health, animal health, or the environment, which relates to items that have already been granted confidential status by the national competent authority. If you could move to the next slide, please. Thank you. And as we've seen, we've got potentially 5 different actors. We've got the notifier, we have the National Competent Authority, we have the European Commission, we have EFSA's Risk Assessment Unit, and potentially also EFSA's Transparency and Confidentiality Unit. And because of this, it was very important that measures are put in place to ensure that there is an efficient collaboration and a consistent approach between the various actors. This is manifested in several ways. First of all, the National Competent Authority has agreed to apply EFSA's practical arrangements concerning transparency and confidentiality when carrying out their confidentiality assessment. Secondly, an IT solution has been put into place to ensure an enhanced workflow between the notifier, the National Competent Authority, the European Commission, and EFSA. This is the ESFC, the e-submission food chain platform of the European Commission, which was previously called FSCAP, which ensures that when the European Commission sends the mandate to EFSA, it also arrives with the confidentiality assessment already having been performed by the competent national authority. And finally, Article 39C review is handled internally in an internal process by EFSA's confidentiality assessment work team if the preconditions that I've mentioned before are met. Next slide, please. Here I would like to emphasize the main principles that have been highlighted by the Transparency Regulation 1381/2019, and which are also reflected in Directive 2001/18. The main guiding principle is proactive disclosure, which is reflected in Article 28.4 of the Directive. Where EFSA is consulted, the notification, relevant supporting information, and any supplementary information supplied by the notifier shall be made public by EFSA on the Open EFSA portal without any delay. This is only subject to confidentiality treatment, which has already been granted by the national competent authority. The details regarding confidentiality are laid out in Article 25 of Directive 2001/18 and set out that confidentiality shall only be granted for items that are included in the closed positive list of the annex to the practical arrangements concerning transparency and confidentiality, and only if the substantive and procedural requirements are also met. I will talk about in more detail both about the closed positive list and about the substantive and procedural requirements. But first of all, I'd like to provide a brief summary at this point. The next slide, please. Thank you. So first of all, it is important to emphasize that the non-confidential version will be proactively disclosed on Open EFSA's portal without delay when the European Commission sends the mandate to EFSA. Secondly, you have to remember that confidentiality is always to be treated as an exception to transparency. Thirdly, the burden of proof will always be on the notifier to ensure that explicit explanations are provided as to why certain information should be granted confidential status. And finally, information that has been claimed confidential will be kept confidential during the decision-making process, and only once the decision has been made under confidentiality request will the decision be changed. Next slide, please. Thank you. I mentioned before that one of the prerequisites about granting confidential status is the procedural requirements as well as the substantive requirements. The procedural requirements are set out in Article 9 of EFSA's practical arrangements on transparency and confidentiality. Under Article 9.1, it's emphasized that the right tool has to be used in order to submit the confidentiality requests. For GMO Part C notifications, this is primarily ESFC, the e-submission food chain platform, but potentially EFSA's own in-house platform called Portalino could also be used for follow-up inconclusive opinions. Under Article 9.2, it's emphasized that for the submission and processing of confidentiality requests, no fees are applicable. Under Article 9.3, it's emphasized that the correct procedural step must be provided, which in this case is Article 28.4 of the Directive. Finally, Article 9.4 refers to the preconditions of both the items needed to be included in the closed positive list contained in the annex to the practical arrangements and to a verifiable justification being provided. And finally, Article 9.5 states that clarifications can only be provided by the applicant if requested to do so by EFSA, either directly via the tool ESFC or via email. That submitting clarifications within deadlines set by EFSA is an absolutely essential criterion. And finally, that modifications of submitted requests are not allowed unless requested specifically by EFSA. Next slide, please. Thank you. I already talked about the closed positive list, which is one of the procedural requirements. And for GMO Part C application notifications, this is set out in Article 25.3 of the Directive. The first three elements relate back to Article 39, 2A, B, and C of EFSA's founding regulation, Regulation 178/2001, the so-called General Food Law. The first item on which confidential status can be granted relates to the manufacturing or production process, including the method and innovative aspects thereof, as well as other technical and industrial specifications inherent to that process or method, except for information which is relevant to the assessment of safety. The second element relates to commercial links between a producer or importer and the applicant. The third one relates to commercial information revealing sourcing, market shares, or business strategy of the applicant. The last two elements are very specific to the GMO Part C notification and firstly relate to DNA sequence information, except for sequences used for the purpose of detection, identification, and quantification of the transformation event, and finally, the breeding patterns and strategies. Next slide, please. In addition to these legal grounds, Article 25(6) of the Directive also confirms that Article 9 of the General Food Law applies mutatis mutandis. What this means is, in relation to the processing of personal data, that, in accordance with Article 39(e)(1), the name and address of an applicant, as well as the names of authors of published and publicly available studies supporting the applications, will always be disclosed by EFSA. In relation to other personal data, it is important that the notifier submits confidentiality requests in relation to those. This could be the names and addresses of natural persons involved in testing on vertebrate animals or in obtaining toxicological information, but it could also relate to any other personal data which fall within the definition of Article 3.1 of Regulation 2018/1725, the European Data Protection Regulation, and allow the direct or indirect identification of individuals. Article 4.5 of EFSA's practical arrangements on transparency and confidentiality makes very clear that the non-confidential version shall not contain any personal data. So it is up to the notifier to ensure that no personal data are included in the non-confidential version. Next slide, please. Thank you. So as I said before, in addition to the procedural requirements, also the substantive requirements have to be met. And the substantive requirements are set out in Article 10 of EFSA's practical arrangements on transparency and confidentiality. In relation to Article 10A of the practical arrangements, it is necessary for the information that is claimed confidential to be clearly identified. In addition to that, the legal basis or the grounds which we have seen under the procedural requirements have to be selected and identified. And under Article 39(10)b of the practical arrangements, it is emphasized that in addition to that, the notifier shall also explain why the item should be kept confidential. In relation to this, the cumulative requirements set out in Article 10b of EFSA's practical arrangements all have to be satisfied. First of all, the information must not be publicly available. Secondly, there must be a potential harm to the notifier if the information is disclosed. Thirdly, the harm must correspond to at least 5% of the gross annual turnover, if it's a company, or of the gross annual earnings of an individual person. If it's not possible for the notifier to quantify the percentage, then a specific reason has to be provided as to why the harm would still potentially be of a significant nature. Fourthly, the information claimed confidential has to be eligible for legal protection and cannot have been unlawfully provided. Fifthly, the information must not fall under the definition of environmental information set out in Article 2 of the ARES regulation. And finally, the information must have been finalized within 5 years prior to the submission of the information. And if that is not the case, additional specific reasons have to be provided if the information is older, to demonstrate why the information should still be kept confidential. Both in relation to the 5% turnover and in relation to the 5 years, the information provided by the notifier will be treated as a rebuttable presumption by EFSA. Next slide, please. So some practical tips for those wishing to submit practical confidentiality requests either to the National Competent Authority or to EFSA in general. First of all, the confidential version of the document has to highlight the information claimed confidential, either by way of a red box around it or earmarked, and the confidential version has to match exactly with the blackened or masked parts provided in the non-confidential version. In the non-confidential or public version, a redaction tool has to be used which ensures that the redaction has been applied in an irreversible manner, i.e. that it's not possible to linger over and remove the information. Thirdly, it's very important to emphasize that only one confidentiality request must be submitted per document and per legal ground. So if you have a document that relates to several grounds, several confidentiality requests need to be submitted. Fourthly, the justification must always comply with Articles 9 and 10 of EFSA's practical arrangements, as I have specified before. Fifthly, you have to ensure that your duplications are avoided. And finally, no confidentiality requests can be made on publicly available information. Next slide, please. When I mentioned before that the respective tool has to be used when submitting the confidentiality requests, and I also stressed that in relation to GMO Part C notifications, the main tool that is used is the e-submission food chain portal. Here, when accessing the tool, it's made clear that both a non-confidential version and a confidential version has to be provided. And of course, you have to ensure that the information is correctly earmarked and irreversibly blocked out, as said before. In addition to that, it's like you have to make sure that the correct legal ground is selected, that a justification is provided as to why the information should be kept confidential. In relation to the ESFC platform, there is the possibility to tick the boxes which concern the substantive requirements and concern the novelty and potential harm worthiness of protection, as well as environmental information. In addition to that, you're requested to put in the excerpt the information that is asked to be kept confidential. For small pieces of information, the entire excerpt should be provided. If it's too large, i.e. concerns entire documents, then it should be made very clear where the location is and from which page to which page the information should be kept confidential. Next slide, please. As I mentioned before, it is also possible to use Portalino for the submission of confidentiality requests, although this is much less likely for GMO Part C notifications. It's a much simpler platform that has been developed by EFSA for the submission of confidentiality requests, especially for inconclusive follow-up opinions in the case of GMO Part C notifications. In the case of Portalino, the confidential version and the non-confidential version have to be uploaded as a zipped file. Otherwise, the same details that I have already mentioned in relation to ESFC submissions apply. Next slide, please. Thank you. And this is an overview of the procedural steps that will be followed by EFSA when carrying out the confidentiality assessment in accordance with Article 39C of Regulation 178/2002. The provisions are detailed in Article 14 of the Practical Arrangements on Transparency and Confidentiality, and Article 14 also details that the whole process shall take 20 working days. As we've said, the trigger for the start of the Article 39C review is the fact that a scientific opinion of the GMO panel identifies foreseeable effects on human health, animal health, or the environment regarding items that have been granted confidential status by the national competent authority. So EFSA will look only at those documents. If there are any uncertainties, EFSA may consult the notifier regarding an optional request for clarification. EFSA will then proceed with the drafting of the draft decision, which will be shared with the notifier as part of the mandatory notification procedure. The notifier will have 2 weeks or 10 working days to submit comments on the draft decision. After that period, EFSA will prepare the final decision, which will be notified to the applicant. The applicant will have 2 weeks to submit a confirmatory application via ESFC or by email. If no confirmatory application is received, EFSA will proceed to the implementation of the confidentiality decision and will eventually disseminate the sanitized documents on the Open EFSA portal. Next slide, please. The sanitization and dissemination process works as follows. So information that is accepted as confidential will be kept blackened as it has been done by the national competent authority. However, information whose confidentiality is rejected will be unblackened by EFSA and will be published together with the revised sanitization of the dossier and documents. Any submission of a confirmatory application or an order from the General Court will put on hold the implementation. And finally, concerning the dissemination of the information, as soon as the confidentiality assessment has been completed and the items have been sanitized by EFSA's specific team, the new documents will be replaced on Open EFSA and will replace the documents that have initially been sanitized by the national competent authority. Next slide, please. EFSA is always keen to engage with its stakeholders and, in this case, the notifier. So anybody who's got any questions in relation to the confidentiality assessment can send an email to EFSA's functional mailbox, confidentiality request assessment@efsa.europa.eu, and we will try to get back with a reply as soon as possible. This finalizes my part of the presentation. I thank you very much for your attention and hand back to Simone. Thank you.
Thank you, Gunda. Thank you for this very comprehensive presentation. Let's say before switching to the Q&A session, for which we received a handful of questions, I must highlight a few additional background documents that are extremely interesting and helpful for the building of a compliant notification and to orientate yourself in the compliance, for the ensuring compliance with transparency regulation requirements, as well as with the compliance with the sectoral legislation requirements. Now, having said this and shared this slide, I switch to the Q&A session, and I actually ask Gunda to join me here to answer a couple of questions that we have received from the floor. So I read out the first question. Dear EFSA, could you please clarify whether an applicant will have the possibility of submitting confidentiality requests under the Article 39C review process handled by EFSA? Gunda, can you?
Thank you very much for the question. Thank you very much for the question, Simone. Actually, no, it is not possible to submit new confidentiality requests in relation to Article 39.7 review process because the review process is based on the decision already carried out by the notified member state. Therefore, no new confidentiality requests can be submitted.
Okay, thank you. Thank you, Gunda. And I would like to switch to another sector and ask Alexandru Dan to join me here, as we received one question regarding where we can find additional details on the ESFC platform created and managed by the European Commission. Alexandru, can you help us on this? Thanks.
Dear Simone, yes, thank you very much for this question. So on the EFSA website, that I will make an announcement, and I will make the website available for everybody. So we have a section there dedicated for user manual. So we have a big user manual which is split per each food domain. And you can find all the information needed and how to submit a dossier for each food domain and what needs to be filled in each section. And also we have some interesting videos that will explain each of the steps depending on the food sector, what needs to be done by our applicants, by the member state competent authorities, by the Commission, and all the other people that are involved in each workflow. Also, the same information can be found directly in the platform in ESFC. On the left-hand menu, you will see there a small box that will send you to support, where you can either send us a question, or if you have some issues, or you can watch the videos and the user manual. Thank you very much. I hope this is answering your question. Now I will give the floor back to you, Simone.
Thank you, Alexandru Dan. Thank you very much. That was very clear. We have received another question concerning confidentiality, and therefore I'm asking Gunda to join me again to answer this second question, which is asking fundamentally how we should understand the box environmental protection for which confidential status is requested, that it should fall under the definition of environmental information pursuant to Article 2 of the ARUS regulation.
Thank you very much for the question, Simone. So essentially, the way this box should be dealt with is if the applicant ticks the box, then this means that the information that has been requested to be kept confidential will not fall under the definition of environmental information. We are aware that at the moment it's a bit ambiguous how this has been framed, and we're trying to make sure that a request for change is implemented to make it clearer to the applicant, and to provide more additional details that they will see as pop-up boxes in relation to the confidentiality request concerning environmental information. The same will also be applied to the other boxes that can be ticked on the ESFC platform. I hope that this answers your questions, but I'm available if this is not the case.
It does. Thank you very much. I see no other questions in scope of the present webinar. So I would like to thank you very much all for having contributed and for having attended to our webinar. We close a bit in advance compared to the planning, but that's also a good sign. And the recording, again, please note that the recording of today's webinar will be available on EFSA's website on the coming days, and take also a few minutes to fill out the evaluation form that you will receive shortly in your inbox. That's very important for us to keep improving our webinars. With this, we close the webinar, and thank you very much again for your presence. Thanks. Have a good day. Bye.